Hello, veterans, aka VA employees, and everybody watching. Hey, welcome back to the channel here at Veteran Lane. Appreciate you as always. Here we are. It's a beautiful Sunday here in the really warm temperatures of the Phoenix area here in Arizona. Um, Hope everybody enjoyed their July 4th, their Independence Day celebration. So I got out there. Got some good food in, some good fireworks. Kept both your hands, perhaps. Yeah, I joke, but at the same time, on a serious note, I do hope everybody came out unscathed, no injuries, and everybody just had a great time overall. 250 years. Wow, still a young nation. At the same time, while we feel so much older. It also makes me think back. Makes me think back to times when I was younger. Not really that long ago, I suppose. But some of the stupid stuff I did with family and friends, and when it came to the celebrations and the fireworks, and I'm pretty sure we did a lot of stuff that we were told we should never do. You know, firing fireworks at each other and all kinds of stuff. But yeah, I think it's a good time to just take a moment. Hey, let's think about those memories and what that was like, and maybe share some of the crazy things we did as kids without really, well, telling on ourselves too much. I think it's great to always get to know each other, especially as we work together to make a system better than what it is today. All right, let's get down to today's video. Hey, veterans, what if I told you that your appeal was never really denied by the board? What if I told you that it was not decided on the merits? What if it was simply closed in a VA tracking system because VA system thought something along the lines like you missed a deadline when you actually filed the appeal on time? Well, this is the issue behind the case called, and forgive me here, I'm not very good with a lot of names, but I believe it's pronounced Freund and then v. Collins. So Freud and v. Collins is one of the most important VA appeals stories happening right now. This case involves legacy VA appeals, which is the old substantive appeals and in the VACOLS system, as the VA knows it, or knew it, for those who may not be familiar, as they might be a little bit newer to the VA. It's also a proposed class-wide settlement that could require VA to manually review thousands of old appeal files. But I also want to use this case to talk about something broader. The difference between VA work being cleared, or quote unquote cleared, or even closed, and VA work being correctly completed. Because from what we see here at the firm, even today, and from my own experience working within the VA, a claim or appeal can disappear from the visible workload in the VA. Later, it might show up under something that's called an EP 930. Now, the end product, the EP, and those three digits is ultimately a tracking system the VA uses to determine what type of claim is filed or what type of appeal is filed or what are they working on. But ultimately, this 930 still represents unresolved work that matters deeply to you veterans. So today we're going to break down what our case is about today, who it may affect, what it does not mean, and why veterans should not assume that a closed VA appeal was always properly closed. So as always, I'm your friendly VA accredited attorney, Matthew Lang, here with Lang's Legal to give you that presentation today. Keep in mind that this video is for general education only. It is not legal advice for your specific case. Every VA claim depends on the facts, the evidence, and the law that applies at the time. I will not do any sort of advising on this platform because the last thing I really want to do is to state something that's incorrect without having all the facts in front of me. So if you think this issue may affect your own claim or appeal, veterans, consider speaking with an accredited representative, maybe a VSO, perhaps that accredited claims agent or an accredited attorney like myself or so many others out there. Let us help you go through that evidence, look to see if your claim actually applies in the situation, see if we can't get something fixed there from the past for you and have VA actually address what they may have missed. If you choose to do that through my firm here, veteranlaying.com is our site currently to schedule that VA case evaluation or that consult, free of charge, no charge to talk to me. Then we can look into things. From there, the site will be undergoing some changes eventually, but the button will be there, and the site's still up as we continue to add on other areas of law and practices of law to help veterans out across not just the nation with VA, but in our local states of practice, Arizona and New Mexico. All right, so why does this case ultimately matter? The VA system is full of words that sound final. You might hear closed, you might hear cleared, completed, decided, no longer pending. But those words not always mean the same thing. A claim can be closed because VA issued a rating decision. An appeal can be closed because the board issued a decision. But sometimes work can be closed because a system control was removed. A deadline was entered incorrectly, a document was not associated with the file in time, or VA believed a required appeal form was missing. And that's why this case ultimately matters. So according to VA's own public notice, the certified class in this case involves claimants with an appeal filed in the old legacy appeal system known as VACOLS. That was closed between December 12th, 1990 and February 6th of 2025. Looks like very much so near 35 years worth of appeals. This is because VA said there was no timely substantive appeal and the appeal remained closed. But in plain English, this is about old legacy appeals again. As I've mentioned a couple times, I just really want to make sure that's clear there, where VA may have closed the appeal because, well, they believe the veteran did not timely perfect the appeal to the board. But the allegation is that some veterans did file the substantive appeal on time and the appeal was still closed. This is a serious problem because in the legacy system, a timely substantive appeal, often a VA Form 9, was the step that moved the case toward the board after VA issued a statement of the case. If that step was filed on time and VA closed the appeal anyway, the veteran may have lost years, maybe decades of appellate review. So let's break this down. Before the Appeals Modernization Act, which we know as the AMA, VA used what was usually called the legacy appeal system and what's kind of referred to as the legacy appeal system today. A veteran would receive a rating decision. If the veteran disagreed, they filed usually some sort of notice of disagreement. VA would then issue typically a statement of the case, if not granting any benefits. After that, the veteran generally would have to file a substantive appeal within the required deadline to continue the appeal to the Board of Veterans' Appeals. And this substantive appeal was often filed on a VA Form 9. Now keep in mind, I'm doing this as a very quick summary in the process, and there might be some other steps and other forms that are kind of left out, but I want you to get the general idea at least. So this is where VACOLS, the Veterans Appeals Control and Locator System, was VA's legacy appeals tracking database. This is before the current VBMS and case flow systems that are in place today. It was used to track and control appeals in the old system. So according to VA's notice, this case is not about every old claim. It's not about every denial. It is specifically about substantive appeals in the legacy system. Now that distinction is going to matter, but at the same time, I think as this case develops, I'm also curious to the idea of how it may apply to the transition more so into AMA, the Appeals Modernization Act, and even into the AMA period. But we'll have to see how that plays out. So let's kind of look at the idea here, though, in the legacy side. So if veterans, your claim was first decided after February 19th, 2019, you're generally in the AMA system and not the legacy system. You could have still been in the legacy system, though. So this is one interesting, tricky part that I think we'll see out of this case. But the case is not about really the modern AMA review options, like the higher level review, the supplemental claims, or the board appeals filed on VA Form 10182 or 10182 currently. This is about the old system at this time, where a statement of the case was followed by a substantive appeal. So VA says that the Veterans Court certified the lawsuit as a class action on March 18, 2026. The parties filed a proposed class-wide settlement, and the court has to decide whether that statement is fair, reasonable, and adequate. So a fairness hearing is currently scheduled for August of 2026 at the Court of Appeals for Veterans Claims, CAVIC, in Washington, D.C. VA says the parties expect the court to live stream the hearing and post recordings afterwards. So if they do live stream it, the date that I have currently is August 13th of 2026. So I believe you can find that typically on a YouTube live stream, but look around and see. It could be something worth watching, especially if you're into this. And VA, I would highly recommend you watch it and pay attention to it, because this could affect your future workload and all kinds of stuff for you and how things are processed. Just my recommendation, though, not my advice. Now, what would the proposed settlement actually do? Well, according to VA's notice, VA identified 28,258 appeal files. 28,258 appeal files that were closed but had one or more documents in VBMS that may indicate a timely substantive appeal. Under the proposed settlement, VA would manually review those files, reactivate appeals that contain a timely substantive appeal, notify the claimant or the veteran, complete those actions in under 18 months, and process the reactivated cases in an expedited manner. VA also says it would send individualized notices for up to 64,599 additional closed appeal cases. That's a significant number above the ones that they have identified, indicating that there are probably much, much more who are affected in this process. They are sending this out to the 64,599 additional closed appeal cases that ultimately meet most, but not all, of the search parameters. Those claimants would have the right to request review if they believe a timely substantive appeal was not processed. This is a large universe of potential effective cases. Ultimately, a small city, it feels like. But here's the caution. Reactivation is not the same thing as a grant to veterans. Just because VA decides to reactivate an appeal that may have been closed out incorrectly in the past, it doesn't mean that they're going to automatically grant your benefits. So if an old appeal isn't reactivated, VA or the board still has to address the underlying issue. The veteran still has to win on the merits. Service connection, rating percentages, effective date, all of that still depends on the evidence and the law. So do not hear this as everyone involved in this case is going to get back pay automatically. That's not what it means. The correct way to say it really is this. If an appeal was wrongly closed, reactivation may restore the appeal path that should have existed years ago. If the veteran later wins, that can create significant effective date consequences. But there is no automatic award just because a case is reviewed. So this is where, again, veterans, it's important to consider your accredited individuals, your VSOs, your accredited agents, your accredited attorneys for help in reviewing all this and ensuring that that reactivated case potentially becomes a win and a victory for you. Now, I want to connect this to what I've seen in practice. This little practice note is a little bit different than perhaps what this case is addressing, but it's something I want to bring to light for the purpose of our mission here, as it's to address additional errors and how this could potentially even blend into the errors that we're seeing in this case, and how VA should perhaps focus in on addressing these errors in order to make a process smoother and maybe limit some of those errors. So at the firm we still see situations where VA clears claims or appeals in a way that later has to be revisited. Sometimes the veteran thinks the issue's gone. Sometimes the online portal looks confusing, and sometimes the claim disappears from one place and reappears somewhere else. Typically, when one tracking EP disappears and suddenly a new one reappears, is what we see a lot of. Sometimes VA later establishes a control, as I've kind of mentioned in my example here, to fix or review something that should not have been closed the way it was. So one end product that can come up in this context is this EP 930, which was mentioned in the beginning. So I want to be careful here. The Freund case itself is about VACOLS closures of legacy appeals involving substantive appeals. It's not about this exact EP 930 case, but EP 930 helps explain the larger workload problem again, and that's really what we want to address when we talk about these type of issues in these videos. VA's Office of Inspector General even has described the end-product system in VA's primary electronic workload monitoring management tool. Even as during a 2017 report. Now you can also find descriptions of this by the VA in their own guidance and manuals and so forth. But if we took what the OIG had explained, which I feel was really clear to help understand this, they explained that the EP 930 could be used where a claim had been previously removed from the system, but was later determined to have been prematurely cleared. So OIG also lists examples including additional evidence not associated before a decision, missed issues, and corrections of quality review errors. So that matches what many representatives have seen in real life. So EP 930 often means VA is correcting something or trying to, reviewing something, or handling work that does not fit neatly into, well, their normal claim stream or perhaps their missions or production standards. So from my experience working within VA, and from what we even continue to see here in practice, the EP 930 work has not traditionally functioned like an ordinary rating production in product. Now, when I say rating production, VA will use these terms of rating production, typically like your new claims, veterans, your increased claims, your appeal claims, supplemental claims, higher lower reviews. But they also have what they call a non-rating in product there, which is typically like dependency, for example. And a lot of the times these 930s may or may not fall kind of in one of those buckets, or in maybe even neither bucket, interesting enough. So it is not the kind of thing veterans usually will understand when VA talks publicly about claims backlog or rating production, and this is matters. Now, what I'm saying here is the idea that when you hear VA say we cleared the backlog, understand from my experience from working within that the 930 is not an EP that's included with that number. Typically, what's happened, perhaps, if there is a 930, is that end product that counts towards that backlog got cleared and it's cleared incorrectly, and now there's actually another end product posted on there because I can't take credit for that same cleared end product, ultimately meaning that the work was never truly cleared. It just appears so on paper, and it still exists in the background. Now, it's usually because if an office is under pressure to reduce inventory, clear end products, or improve aging numbers. The question for veterans is not just did VA clear the work, and it's the better question really is, did VA actually do the required work correctly? And that's really what I'm trying to get to here. Is are we doing the work correctly at the VA, or is it being done right in consideration of the veteran here? That's really the heart of this issue. A cleared control is not the same as a correct decision. A closed appeal is not always a legally valid closure. A case disappearing from the queue is not always the same as the veteran receiving the process they were owed. Now, let's kind of look at this on why this could hurt the veteran and kind of what it means in real life. So a veteran, for example, files a claim. VA will deny it, perhaps, for whichever reason. The veteran has the ability to disagree. So they do. VA issues a statement of the case or some decision currently. The veteran submits, if it was a legacy claim, the Form 9 that was on time. So let's look at that. Let's look at this example through the legacy side. So let's say veteran, you filed a claim, VA denied it somewhere, you filed a disagreement properly underneath the legacy appeal system, and the VA issued a statement of the case. And then you submitted that Form 9 on time, but then nothing happened. Years go by. Well, maybe the veteran assumes the appeal died, or maybe the veteran decides a new claim needs to be filed, or maybe it's just the idea that so many years go by because it was not uncommon for a legacy appeal to take 10 plus years and you just assume it's being worked on. Maybe it's not. So let's still take the idea that the veteran assumes it died in this example. And because they assumed it died, they decide to file a new claim later. And maybe VA grants the benefit years later, but only gives the effective date from the new claim, not the old appeal. So if that old appeal was actually still alive, the effective date consequences could be enormous. That does not mean, again, every old claim can be revived. It does not mean every veteran with the old denial is part of our class action suit here, but it does mean veterans should take old appeal history seriously. The mistake I see all the time is assuming that because VA says something is closed, the legal story is over. Sometimes it is, sure, but sometimes it's not. So ultimately, who should pay attention? Well, you should pay attention to the case if you or a family member had a legacy VA appeal, um, where, say, VA issued a rating decision before February 19th, 2019. Maybe you filed a notice of disagreement. VA issued a statement of the case. Perhaps you filed a substantive appeal or VA Form 9 then. VA later treated the appeal as closed because it said the substantive appeal was not timely. And the appeal never received a board decision. Survivors of veterans should also pay attention because VA's notice says substitute claimants may be class members if they have substituted or are eligible to substitute for a class member. So again, do not guess based only on memory. These cases are document heavy. You want the rating decision, the notice of disagreement, the statement of the case, the VA Form 9 or other substantive appeal, proof of mailing or faxing if available, VA letters, and ideally the claims file itself. So something to consider, veterans. You may want to first, if you receive that letter about the Freund case here, I wouldn't necessarily ignore it. I can't tell you what to do on that, nor am I going to advise on that, but you may not want to ignore it because something can be corrected here. Read it carefully. Keep the envelope, keep the reference number. Do not throw anything away. Second, look for your old appeal documents. The most important documents are that statement of the case and substantive appeal. If you have a copy of the VA Form 9, a fax confirmation, a certified mail receipt, a date stamp, or correspondence from a representative, make sure you preserve it. Third, if you believe you had a timely substantive appeal that VA did not process, talk with an accredited representative. Again, the VSOs, the VA accredited agents, the VA accredited attorneys like myself, and so many other firms out there. Make sure they're VA accredited. There are way too many people out there who are getting away with not being VA accredited and taking advantage of the idea that the VA does error and that veterans are looking for help. And then ultimately veterans, they take advantage of you. So make sure you talk with an accredited representative. So this is exactly the kind of issue where the words are going to matter. In this case, in this scenario, veterans, if you have it, was it a notice of disagreement? Was it a substantive appeal? Was it filed after a statement of the case? Was it timely under the legacy rules? This is something that accredited representatives would be able to better walk you through and understand, and then you wouldn't have to necessarily be as stressed or fight that alone. Now, fourth, do not assume that a new claim solved the old appeal. A later grant may not fix the effective date problem if VA treated the old appeal as final when it should not have. Again, evidence could change things. And I'll leave the blooper in there. Apparently, I didn't move enough. My light shut off on me. So, must mean I'm getting too winded here. Let's go ahead and kind of finish this up. So fifth, what we're talking about here is ultimately be very careful with anyone promising huge back pay. That's a concern here. This case may create real relief for some veterans, but nobody can actually guarantee an outcome without reviewing the actual file. I will never guarantee you an outcome. I can't. There's a lot in play, but I can tell you how strongly I may feel about that and how strongly I feel a win is possible. But anybody who's giving you guarantees, be careful. Be careful there. Now, for VA employees and perhaps even some of the representatives out there, remember this case is also a workload integrity story. The public often hears about backlog numbers, production numbers, and claims cleared. Those numbers matter, but they do not tell the whole story. We've been talking about this periodically. They never tell the whole story on the surface. When unresolved work is prematurely cleared, when documents are not associated before a decision, when a control is removed before the required action is taken, or when an appeal is closed because the system did not reflect a timely filing, the veteran may lose the process that Congress and VA regulations required. And these errors can be hard to spot later. The veteran may not know the right term. The portal may not explain it. The record may look final unless someone understands the procedural path. This is why representatives need to reconstruct the timeline, not just ask, was there denial? Consider asking things like this. Was there an SOC? Was there a Form 9? Was there proof it was timely? Was there a board docket number? Was there even a board decision? Was the appeal closed untimely? Did VA later establish a control like EP 930 to correct or review something? And if VA granted the same issue later, what effective date did VA assign and why? Those are just some questions that can change the entire case. And for us back here, we're going to be thinking of so many more to try to change the outcome of that case and then correct any error that is inside your case, veterans. So let's clear up just a few misunderstandings potentially here. First, the Freund case is not about every denied VA claim. I want to make sure that's as clear as possible. It's about a specific category of legacy appeals right now involving substantive appeals. Could it later apply to other cases? Maybe. But right now, it is the focus of the legacy appeals. Second, the case is not a final approval yet. So as of now, the court still has to decide whether to approve the proposed settlement. So we got to keep an eye out on it. We are talking about it today as if it was approved. I really feel like the court would approve something like this, and maybe I'm wrong, but I want to make sure that we address it as if it was approved because we want to fix those mistakes. We want to make sure those are cleared out of the system, whether the court approves this or not. We want to do right by veterans. Third, being reviewed does not mean automatic benefits veterans. The underlying appeal still has to be decided. Fourth, an old appeal problem may affect the effective date, but only if the facts and the law support it. Again, that's pretty much the case with all your situations, veterans, is the facts and the evidence and the law all has to support the decision. So fifth, the EP 930 is not a magic phrase. If you see it, it may indicate correction or review activity, but you still need to know what issue VA has controlling and what action VA actually took. So VA, you got to know that too. And veterans, I think it's important that you know that as well, so you can keep documentation of this and make sure the mistakes are cleared up later on. So final takeaways. Here are the main takeaways. The Freund v. Collins case is important because it shows that old VA appeals may have been closed in a system even when veterans had filed the required appeal paperwork. Again, I still feel it's going to become important because I think we still see similar things like this even after the legacy system. The proposed settlement could require VA to manually review more than 28,000 files and send notices involving up to 64,599 additional files. VA, this is important for you as a final takeaway because having in your shoes for over 13 years before practicing outside of the VA, is having to review a number of files while trying to manage the workload you currently have has become a challenge for VA in different scenarios. So be ready, because, well, it can only make your job easier if you're actually ready for it, in my professional opinion. The key legal issue is narrow: legacy appeals, VACOLS closures, and timely substantive appeals. But the broader lesson is much bigger. VA clearing a claim or appeal is not always the same as VA correctly completing the work. That is true in the context of this case today, and it is true in the modern work. We still see when VA has to revisit prematurely cleared work, missed issues, unassociated evidence, or correction controls like EP 930s. And again, I bring these up because this is something that we fight in the firm here for veterans, and we see fairly routinely, and it appears to be growing from our point of view. Again, I do see the bad and the ugly, but it does appear to be growing from our point of view. There tends to be more mistakes and misclaims and perhaps even EP 930s established. So if you had an old appeal that seemed to vanish, do not rely on rumor, do not rely only on memory. Look at the documents, rebuild the timeline, get the claims file if needed. And one really good way of probably doing that is through an accredited representative who will be able to get it faster than your FOIA request that will likely take 8, 9, 10, 12 months to fulfill. And consider speaking with an accredited representative again who understands the legacy appeals and effective dates so they can actually rebuild out all that timeline and evidence for you. But veterans, you're always welcome to go at it on your own. And if you feel capable of doing so, then give it a try. I know there's a lot of talk out there about you shouldn't have to pay somebody to help you out and so forth. And those are valid opinions and of others. So I'm not here to sell you anything. I'm not here to say you can't do it on your own. I know it could be possible, but do understand you do have a lot of representatives and advocates out here working for you and here to help you in the event that you find yourself hitting a wall or becoming overly frustrated with the process. Now, if this video helped you understand some of our problems and happened to help you understand the case today, don't forget to subscribe to Veteran Lang. We look forward to doing much more videos like this in order to help understand the process and smooth the process. And we'll continue doing videos as well that help understand how to file claims and teach the different aspects and theories and foundational elements and so forth. So look for all this on the channel. And then ultimately, if you do have an old VA appeal, especially one involving a statement of the case and a VA Form 9, it's a good time to pull those records and make sure that the appeal was actually decided and not just closed, especially if the court approves this case here. Because, VA law, the difference between closed and correctly closed can be the difference between losing years of benefits and preserving the effective date that you've earned, veterans. So I will put some additional information in the description here. I'll try to link in the case too, so you can read that at your leisure there if you like. I would recommend highly that you review it so you're up to speed on what's going on around your career field. And veterans, I would recommend you do too, just so you can kind of keep up to speed on that. But hey, I get it. Practicing law is not everybody's cup of tea or reading court cases. So I'll put it out there just for you, for those who want to review it. Ultimately, I thank you again, everybody, for being here at the channel and sticking around. If you made it to the end of this, greatly appreciate it again. Don't forget, we're trying to build a firm here that provides more personable assistance to veterans, a firm that understands veterans, is veteran, well built by veterans. I do want to make sure that even the other fields that we practice in and we offer to veterans over time is at a more affordable rate than most attorneys. I don't feel you should have to overspend in order to get that help. So keep an eye out for the changing of our website. Veteranlang.com is right now our main VA benefits website, and Lang's Legal is being recreated to start addressing, well, langslegal.com is being recreated to address a lot of the new issues that will be available to veterans and those in the communities in New Mexico and Arizona. So thank you again. From your friendly VA accredited attorney, I look forward to another video with everybody. And I got to move again. I'll talk to you later. Have a good one.